highlighting the disconnect between law and reality, asking the question of whether the marginalized is really left behind or are left behind in the process. And I think just as a background to the lecture is the fact that South Africa has aligned itself with these UN Global Sustainable Development Goals, or SDGs as they're commonly referred. And as you'll see there, the first goal is to ensure that poverty in all forms is ended in South Africa by 2030. That's a really high goal set for ourselves, but I think it is important to realize that when we start with looking at these sustainable development goals, of which we have 17, the first one is essentially set very high at aiming at alleviating poverty in all forms by 2030. Goal 10 is another goal that I see playing into my particular field or my particular field of interest, and it speaks to reducing inequalities, and the aim is really to narrow the gap between the rich and poor. Now, this should purportedly be achieved by adopting policies that create opportunities for everyone in South Africa. Another goal that I think is important when it comes to property or land, more specifically, is goal 11, which in turn talks about sustainable cities and communities and really emphasizes the particular need to ensure that cities and human settlements are made more inclusive, safe, resilient, and sustainable. The focus of goal 11 is also to seek to eliminate extreme poverty in city centers and make these areas where many of us choose to live more affordable by providing public housing. Now, this potentially speaks to something that one of my LLD candidates is looking at as well, is upgrading of urban slums or urban settlements and getting a broader range of people involved in decisions about urban planning. Now, we were represented, as South Africa, we were represented by former President Jacob Zuma at the the United Nations Summit on Sustainable Development, which was held in New York in September 2015. And it was really at this summit where these SDGs were, deliberated and more specifically adopted. In his, here is just a picture of the summit. In his statement delivered after the summit, former President Jacob Zuma indicated that South Africa endorses this transformative post-2015 development agenda without reservation. But, and I think this is important, he also emphasized the fact that the ability to adopt these goals depends on the particular national realities, capacities, and levels of development that requires respect for national policies and priorities. And in today's lecture, I'd like to place the national reality, policies, and priorities in South Africa at the moment in the spotlight. Now, the point is not to paint a bleak picture of how far we've come in terms of, in our country, in terms of poverty alleviation, but I really want to try and identify some of the challenges that I see, at least, with this particular reality that we face, specifically in this quest to try and move towards a more equal society in South Africa. In 2008, the World Bank, in consultation with Statistics South Africa and the Department of Planning, Monitoring and Evaluation, released a report in which it sought to identify the key drivers, constraints, and opportunities in this quest for overcoming poverty and inequality in South Africa. Now, the study is really fascinating, and it does it identifies quite a number of issues. As you can imagine, it is a multifaceted and complex issue. But one of the things that kind of stands out of this report, I think, is that it's clear in this report that South Africa is one of the most unequal countries in the world. So let me show you a little bit of this reality. I'm going to show you a little of the reality, and then I'll bring it back to law and some of the things that I've picked up in the legal context, specifically property. Now, this picture was taken by Johnny Miller, who went around South Africa and kind of tried to give us a bird's eye view of various areas in South Africa. And this picture, I think, paints quite interesting story in terms of the stark inequality that exists, or clear dividing line that exists between the rich and the poor. You'll see, for instance, it's just a road that is separating what's at the top of the picture, which is a considerably poorer area, and then you have a suburb with roads and houses on quite big plots, more towards the bottom of the picture. Really, again, showing in Miller's words, this divide or this unequal scene of what we potentially see in South Africa at the moment. He made the comment that some of the communities were, of course, designed with separation in mind. And I think if you have a look, it's quite clear to see kind of this is how it was designed in terms of apartheid. And others, he notes, grew more or less organically over time, right? Started off in a certain way, grew, changed, moved around. But in essence, this is at least one glimpse into some of the inequality that we still, or the reality at least, in terms of what we are still facing. And he notes, he took these pictures where it was 20 years after the constitutional, 22 years. Of course, we've come a little bit further now, but he notes that it's been 22 years since these policies were eliminated, these apartheid policies. But in reality, many of these barriers and the inequalities they have engendered still exists. Picture 2 kind of really gives you the same type of indication. So you have on the left a community here in Cape Town, about 20 kilometers south of Cape Town, Masipumelele community. And this community consists of about 38,000 inhabitants, many of them living in what is tiny, really very small shacks, very close together, very populated on the left-hand side. And then you will see on the right-hand side, and interestingly enough, only 200 meters away from each other, which I thought was quite an interesting dynamic. 200 meters away, you see the wealthy community of Lake Michel on your right-hand side. And surrounding Lake Michel, you also see a number of other really wealthy suburbs, like, for instance, Chapman's Peak Drive. I think also, again, showing this vast difference between, rich and poor communities living actually quite close together, but obviously living very differently. And it's really only this wetlands that is separating the two communities. And like I said, only 200 meters apart. So in actual fact, really close together. I just wanted to show you, so this is Masipumelele which is portrayed in the previous picture on the left-hand side, and then the stark difference that you see in Lake Michel on the right-hand side. Right, and this is just, this is one or two examples. There are many other examples that exist in South Africa, and I think this is the reality that we're facing in South Africa at the moment. In Stellenbosch alone, we know that the spatial inequality, if you just drive into Stellenbosch, is telling. It's clear. There you'll see a picture from Kayamandi and the rest of Stellenbosch on the right-hand side, on the back. So also an interesting dynamic playing out here in Stellenbosch itself. But I think what is clear, and I think this is just some of the national reality that I'm trying to portray as a start to looking at the legal implications or some of the legal questions that I specifically am interested in, is that we have the rich and poor inhabiting spaces that are sometimes very close together, but very different. And many social justice lawyers are concerned with the extent to which the law can and should play a role in reducing or alleviating some of these poverty experiences or these poverty levels, but also then, of course, structural inequality in South Africa. And while South Africa arguably has constitutional provisions and laws implemented in terms of these constitutional provisions that are extremely progressive, these laws or constitutional provisions will remain only ideals if they don't speak to a particular reality. Now, I see, or I would argue, that there are two problems that potentially emerge when I start looking at it through a legal lens or start asking questions in terms of legality in this regard. And the two problems, I think, can be separated, all of them under the umbrella of the disconnect between law and reality. But I think the first problem is really implementation issues. Now, this is one aspect that arguably makes it very difficult to reach poverty alleviation, or at least just drastically reduce poverty levels, because there seems to be a disconnect between the laws that are in place to protect marginalized groups and the implementation of those laws. The other problem that potentially exists that we've seen in a number of cases as well is that there seems to be a failure in some contexts of the actual laws responding to the particular realities of a marginalized group. So it's not necessarily an implementation issue. It could also, go into implementation, but this one speaks more to the appropriateness of a law to speak to a particular reality. And I'm going to try and elaborate on these aspects to some extent today. We've had a number of pronouncements by justices in various courts that kind of speak to this disconnect between the ideals of the Constitution and the implementation of legislation, policies, or bylaws. And what I want to reflect on today is this disconnect in the context of marginalized groups, more specifically the landless and the homeless. Of course, to the extent that these groups don't in any event overlap. So you could have an instance, you could be landless, but you're not necessarily homeless. So to a certain extent, they do overlap, but they don't always overlap. And it's really within this space, through a legal lens, that I want to engage with the question of whether the SDGs, as necessary and noble as they may be, are realistic in the South African context. Now, arguably, the imperative of land reform to address more substantial equality in the context of land has woefully disappointed the landless in South Africa. Just two judgments handed down in this year immediately spring to mind when I make that statement. The first one being District 6 Committee and others versus Minister of Rural Development and Land Reform. And this was an application that was brought by the former residents of District 6 to resolve and to bring to finality their claims for restitution, which of course arose due to the dispossession of their homes and properties in District 6 in about 1960. And it was in this decision very recently that the court held that Section 237 of the Constitution provides that all constitutional obligations must be performed diligently and without delay. That this should be so is of course self-evident. Compliance with the supreme law affirms and validates the law, while dilatory conduct not only undermines that law, but also deprives the bearers of constitutional rights of timeous performance of the obligations owed to them. It must follow that a relatively young and fragile democracy such as ours must ensure that the letter and spirit of the Constitution is internalized into the DNA of the state and the rest of society. A strong commitment to performing constitutional obligations without delay, diligently and conscientiously, contributes not only to the consolidation of democracy and greater respect to the Constitution, but also engenders confidence amongst all of us that the law can and indeed does work, and that the imperatives contained in the Constitution are more than the paper promises, but promises of substance that can be enforced. Right, so that was just a recent judgment dealing with land reform. And of course, the court continued to indicate that it is in the discharge of that duty that the respondents have failed. And their failure lies in the non-delivery of homes to successful claimants some 20 years after claims were submitted. Their failure lies in the reality that even 20 years later, there is no plan and no timeline for the adoption of such a plan. Their failure lies in the inability to recognize and to properly respond to the plight of the claimants, as opposed to a legal response that says we have complied. And given the history of dispossession, an enormous political and legal imperative to make good on the redress the Constitution promises, the failure becomes even more telling. Similarly, Davis J. in the recent judgment of Zsa-Zsa and another versus Minister of Rural Development remarked that since the birth of democracy in our country in 1994, land reform, despite it being a constitutional imperative, has been slow and frustratingly so. So if we have to be honest with ourselves regarding the slow pace of land reform, we see that identifying where the problem lies is very complex. Saying that we have laws that are not being implemented, in my view, is only one aspect of the problem, because the question of non-implementation is just so loaded with complexity. One part of the problem can be that these laws cannot be implemented, as honourable as they are, because they simply don't speak to the particular reality. For instance, and sorry I'm going into legal terms now, but I'll try and explain it as elaborately as possible. The Prevention of Illegal Eviction from an Unlawful Occupation of a Land Act, which is commonly referred to as the PI Act, has been set up to protect unlawful occupiers against illegal evictions. But PI doesn't always cater for the fact that a home is simply not the same for everyone. And I know a lot of work has been done in terms of the definition of home, but I think it's been called into question very recently in a case which I'll discuss with you in just a short while. The physical construct of what constitutes a home may be fundamentally different for someone who lives on the streets. It can, of course, also be that the laws are not implemented because there simply isn't the political will to implement them. So I think it's important to take account of the complexity that is associated with the non-implementation of existing laws, aimed specifically at protecting and safeguarding certain rights in the context of land reform. I don't think we can be ignorant, or we should be ignorant of the fact that non-implementation is extremely loaded with complexity. Parallels can be drawn between the situation of the landless and the homeless, to the extent, of course, as I mentioned earlier, that these two categories, if you will, or groups do not overlap. In the case of the homeless, the laws and policies in place do not always appropriately fit the particular realities and challenges facing this group. Moreover, we've seen a number of cases, which I'll share with you in just a short while, where the laws and policies are simply being disregarded. Interestingly, in both the context of the landless and the homeless, recent courts have been quick to point out this disconnect and the importance of guaranteeing more congruence in this regard, so as to ensure more adequate protection of these marginalized groups. There's a particular narrative that is evolving regarding these groups, especially in terms of how they should be treated in the constitutional dispensation. And I hope to highlight some of this narrative because I strongly believe that this narrative should come to the forefront when we begin to engage with the question of whether our laws are adequate and enforced in the context of the homeless and the landless. I would submit that if the laws in reality are not aligned more appropriately, not only are the constitutional rights of these groups ignored, but the prospects of reducing poverty in South Africa, especially with regard to minimizing that gap between the rich and the poor, are substantially hampered. So let me begin by sketching a scenario that is happening all too often at the moment in South Africa in relation to the way in which homeless or landless people are treated. And now I've skipped many things that I haven't. I'll leave that. Let's do that. So I'd like to begin with the details of the situation in this picture that led to the case that was decided in the Supreme Court of Appeal in April 2019. In Nungamani versus City of Johannesburg Metropolitan Municipality, the Supreme Court of Appeal had to consider the plight of 27 homeless and destitute people whose belongings and materials were confiscated and destroyed by officials of the JMPD, Johannesburg Metropolitan Police Department. So this particular scenario played out in Johannesburg. I'll mention in a short while similar scenarios that played out in Pretoria and also other areas. The applicants in this particular case had made a shelter for themselves on a traffic island under the bridge in the central business district of the City of Johannesburg Metropolitan Municipality. Now, although it's always difficult to determine the exact numbers, there were 27 applicants in this case, and it was clear that the majority of the applicants had made an overnight shelter under the bridge for about 2 years. 22 members of the group allegedly collected and sold recyclable materials and made an income out of that of approximately 350 to 1,000 Rand per month from, of course, selling these materials. And for all intents and purposes, they regarded the traffic island as their homes. So where they erected their overnight shelters with various materials as their home, and they returned to the home after the day of search for food and work. So that what they would apparently do is to go out in search of food and work, and then leave their personal belongings and materials on the traffic island, come back after the day to set up their makeshift shelters again. So they actually themselves broke down or took down the temporary makeshift shelters and re-erected it at the end of each day. So these makeshift shelters were then comprised of cardboard boxes, wooden pallets, and plastic sheeting. The disputed event that gave rise to the need to actually go to court occurred when the JMPD arrived at the traffic island one day with municipal vehicles and waste removal trucks and confiscated the materials and the applicants' personal belongings. The applicants also alleged that the officials mistreated them physically and verbally and sprayed them with pepper spray. The applicants argued that the city evicted them from their homes in violation of Section 26(3) of the Constitution and arbitrarily deprived them of property, obviously in their personal belongings, in terms of Section 25(1) of the Constitution. Right? So it was in terms of those two constitutional provisions that they essentially made their arguments in the Supreme Court of Appeal. So it's eviction from the home in terms of Section 26(3), and then it was arbitrary deprivation in terms of Section 25(1). They also asserted that the city's conduct resulted in an infringement of their rights to adequate shelter and human dignity, also constitutional rights. In its defense, the city, as the respondents, contended that it had a subunit of the Department of Social Development aimed specifically at dealing with the ongoing problem of displaced and homeless persons. This subunit apparently had various programs in place to help displaced people in the city, specifically to help them to get off the streets and to generally improve their standard of living. The city also indicated that there was in fact one of those shelters very close to the traffic island in question, but that this particular group had chosen and not been interested in the particular shelter. Now, besides this more general defense, the city contended that the materials and belongings of the applicants were removed by the JMPD in this particular instance in terms of what called a cleanup operation in line with the city's bylaws. The particular bylaw that was apparently applicable in this case was the City of Johannesburg Metropolitan Municipality Public Health Bylaws. The JMPD was purportedly acting because there were numerous complaints by nearby businesses concerning specifically the occupation of homeless people in the custom and public vehicle parking area and various grievances related to this group being social interferences. The city went on and explained that it was simply rubble removal and that no eviction or demolition of any homes had taken place in this particular case. They also argued that the homeless people abandoned the materials and personal belongings, and the JMPD was therefore simply removing materials that people in any event didn't want or had discarded of. They maintained that they had a policy in place in terms of which they ordinarily sorted through the rubble and avoided discarding of any valuable or personal items. What they would then do, according to them, was to keep these items safe, and the owner could then come back and collect it at any time. It did transpire in this particular case that the city, in fact, had failed to sort any of the materials or belongings collected on that specific day and simply discarded of all the materials. This was also substantiated by video footage, which was made available to the court, and it was clear that the city was aware that they were dealing with this very particular group and that they didn't sort out any valuable or personal items, which could then be preserved for an owner to come and collect. So let's quickly have a look at what the Supreme Court of Appeal does in this scenario. The court held that what was required in this case was a remedy for this particular group that would vindicate all the constitutional rights that were violated. Firstly, the confiscation and destruction of the applicant's property was a patent, arbitrary deprivation thereof in contravention of Section 25(1) of the Constitution. Therefore, the court accepted that the cynical and blatant destruction of the materials and belongings of the applicants was in contravention of a property clause in the South African Constitution. The court also concluded that the conduct of the respondents in seizing the applicant's possessions resulted in a violation of their right to privacy in terms of section 14C of the Constitution, and the respondent's conduct was also held to be in breach of the applicant's right to human dignity in terms of section 10 of the Constitution. So on the basis of all these violations of constitutional rights, the court relied on section 172 of the Constitution to declare the respondent's conduct unlawful and emphasize that the applicants were entitled to what is called appropriate relief in terms of section 38 of the Constitution. Now, in different scenarios, it may be that appropriate relief would mean that the courts can choose from existing remedies in any particular case, but it could also be that courts could devise and create new remedies to be appropriate in a particular case. And we've seen different variations of what constitutes appropriate relief in different cases. I think what is important if we look at the line of cases dealing with appropriate relief and what constitutes appropriate relief is that it has to be effective relief so that it can vindicate the constitutional rights that were violated in the very particular case. And the court essentially sought to do that in this case. Now, just in terms of what the remedy was, I'll say something briefly about that. The applicants sought, of course, the return of the destroyed materials and belongings, but we know that it was destroyed, so it couldn't be returned in this particular case. And so the question did arise whether the respondents could substitute the property that was destroyed. However, this property wasn't adequately described according to the court, and it was really difficult for the court to engage, as one may think, with determining what would be the commercial value of these goods that were lost. Of course, it was clear that these items were highly valuable to the owners, and in most cases, it was really all that they had. But I think the saving grace for the court was that the applicants were willing to accept, or indicated that they'd be willing to accept 1,500 Rand as compensation for the destroyed property, and the court took that lifeline and awarded that 1,500 as appropriate relief in this particular case. However, this amount only included the value of the purported value, if you will, of the personal belongings that were confiscated and destroyed, and it didn't really take into account, it didn't actually take into account the makeshift shelters, which of course was made of cardboard boxes, plastic sheets, and wooden pellets, which effectively was their homes, or were their homes. In the end, the Supreme Court of Appeal contended that 1,500 Rand for each applicant would constitute appropriate relief in terms of Section 38 in order to vindicate all of the constitutional rights that were violated in this case. The court also granted what is called a declaratory order, in terms of which the city was ordered to pay that 1,500 Rand within a certain amount of days, 30 calendar days from the date of the order. And I think very importantly, the court declared the conduct of the respondents unlawful and unconstitutional, and stated that it was hoped that the declaratory order in this case would deter the city from dealing with homeless people in this way in future. So why, you may ask, did I share the details and particulars of this specific case with you? I shared it with you because I really see this case as an illustration of something that is amiss in our constitutional democracy. I think very fundamentally, to link it with what I am talking about in this lecture today, there's an ultimate disconnect between the laws that are in place to safeguard constitutional rights and the implementation of those laws in reality. Now, many people might look at the outcome in the Ngamani judgment and applaud the court for reaching a solution that aims to provide the applicants with an effective remedy. And to a certain extent, I agree with that. Of course, this is a victory for the applicants in the sense that the court was at pains to point out that there were constitutional rights that were violated, and the remedy should provide relief for those violations. However, we can probably have a long conversation about whether 1,500 Rand was really effective relief in this particular case. Be that as it may, I can accept that there are many parts of this judgment, especially the outcome of the judgment, that should be commended. But I think there are also a number of really disconcerting aspects of this whole scenario. I'm concerned with the conduct and attitude of the respondents in their dealings with the homeless and the landless people in this case. The respondents purportedly acted in terms of a bylaw or the bylaw to protect public health. But what do these bylaws say? And to what extent did the respondents act in terms of these bylaws? Also, can these bylaws give the respondents free range to act against the homeless and landless for the sake of public health, even in contravention of constitutional rights? Now, of course, clearly the answer to these questions is no, right? The Supreme Court of Appeal at least confirmed as much in its outcome. But the court didn't really provide us any further clarity on the use of the bylaw in this particular case, or the use of bylaws more generally to substantiate this poor behavior by municipal officials. Magnus Kilander wrote a fascinating article now in April, it's not now anymore, but in April 2019, entitled Criminalizing Homelessness and Survival Strategies Through Municipal Bylaws, Colonial Legacy and Constitutionality. And interestingly, in this article, Kilander provides quite a rich historical analysis of some of these bylaws and where they actually come from. What he shows is that most of these bylaws, if not all of them, are essentially aimed at criminalizing homelessness. He also shows that many of these many of these bylaws rely quite heavily on vagrancy legislation in South Africa, and that most of these bylaws are not really set up to be pro-poor. Kilander looks at the bylaws or some bylaws in the four largest metropolitan areas, Johannesburg, Tshwane, eThekwini, and Cape Town, and makes an interesting argument that these bylaws are essentially enforced to provide a sense of security among the privileged by removing an undesirable persons from the streets. If I were to take Kilander's argument a bit further, I think a number of additional questions can potentially arise consisting the use of, or in the context of the use of bylaws. Firstly, to what extent are these bylaws being used to enforce established hierarchies in society? And are there mechanisms in place to ensure that law and order in terms of these bylaws is not being used as an excuse to trample on people's constitutional rights? If we take these questions back to the particular bylaw in the Ngungamani scenario, there are a few things that I wonder about. It's not clear to me, for instance, that the particular bylaw was in fact even followed in this case, especially to ensure the respondents what they called the cleanup operation. If one looks at the provisions of the bylaw, of which nothing is discussed in the case, it's not clear that the bylaw was even necessary to avert any sort of public health hazard in the case. Now, in the absence of stating that particular purpose of the bylaw in that particular case, it's questionable whether the municipality knows how to act in terms of the bylaw or did in fact act in terms of the bylaw. Nothing in the bylaw speaks of how a municipality is supposed to enforce the bylaw, for instance. Besides some indication which I found, although it wasn't mentioned in the case, which I found in the bylaw that notice should be served on a person, there's no procedure to indicate how this bylaw will or should be implemented. Arguably, if it is not clear to a municipal official how he or she should act to enforce the bylaw, the risk is so much higher that the conduct may infringe on some or other right, as was clear in Ngungamani, but also some other cases which I'll mention very shortly now. Another concern that I have in relation to the use of the bylaw in this particular case is that I wonder whether the bylaw was not used as a smokescreen to avoid legislation that has specifically been enacted to or put in place to safeguard constitutional rights. And I have to apologize here. Again, I'm going into very, for the non-lawyers in the room, I just have to go into a term that we use in legal terms, subsidiarity principles. I think we have sufficient precedent at the moment in our law for what is termed subsidiarity principles, which potentially in this context would mean that you cannot use a general bylaw bypass a specific piece of legislation. especially if that legislation has been enacted to give effect to a constitutional right. It would then not be the appropriate course of action to use a general bylaw, for instance, a public health one. So for instance, where PI, the act that I referred to earlier, has certain procedural and substantive mechanisms to safeguard the constitutional rights of these marginalized groups, if it is found that PI is not applicable, as was done in this case, it should arguably be determined whether PI falls short in some way. Perhaps we need to revisit our understanding of what constitutes a home. Or maybe PI should provide better protection in the context of unlawful occupation of land and not be so heavily focused on eviction from a home. Alternatively, it needs to also be established whether there's maybe another piece of legislation that could have been applicable in this case. I think, for instance, of the Disaster Management Act or the National Buildings Regulations and Building Standards Act, which also has specific procedural and substantive mechanisms in place to protect the constitutional rights of marginalized groups. I think if one doesn't do this exercise of establishing beforehand in terms of which piece of legislation, policy or bylaw a particular municipal official or state representative is acting, you really run the risk of them acting out of line and ultimately endorsing what I would see as a type of structural inequality that we're really trying very desperately to avert in South Africa. In fact, the conduct portrayed by some municipal officials in dealing with the homeless and the landless in a number of cases, this is just one example, is shockingly reminiscent of apartheid-style mishandling of marginalized groups. In this regard, the scenario in Ngungamani is unfortunately not new or even uncommon in post-apartheid South Africa. The judgment actually confirmed in line with Twelepele non-profit organization versus City of Tshwane Metropolitan, that in instances where constitutional rights have cynically and deliberately been violated by the municipality or municipal officials, courts are obliged, in line with Section 172 of the Constitution, of course read with Section 38, to determine a remedy that is appropriate in the particular instance. Now in Twelepele, the Supreme Court of Appeal also had to deal with a situation where occupiers of a vacant piece of land in a Pretoria suburb were evicted from their homes and their homes demolished without peremptory eviction proceedings having been followed. Right? So we have legislation was not followed in this particular case. The Supreme Court of Appeal in Twelepele created a new constitutional remedy to vindicate the occupiers' rights that were violated. In the Constitutional Court, in the Constitutional Court decision of Schubert Park Residents Association and others versus City of Tshwane Metropolitan Municipality, the Tshwane Metropolitan Municipality again expelled unlawful occupiers from a badly run down and significantly deteriorated residential complex in Pretoria without following any eviction or evacuation laws. Again, the court in Schubert Park was forced to provide a constitutional remedy under Section 38 in order to rectify the violations that had taken place, specifically due to the blatant disregard of eviction legislation. And in these three cases, courts should be applauded for the way in which they sought to vindicate the violation of the applicant's constitutional rights. It was always clear from the start in all three of these decisions that the court was looking for a remedy to vindicate the rights that were violated. And really the only question that one gets a sense in all three cases is how are we going to effectively or find a remedy that is effective in the particular case. But I think very importantly, these cases are about humanity. More specifically, they illustrate that story that I was talking about at the beginning, about how homeless people should be treated in the new constitutional dispensation. In other words, they should not be treated as social outcasts or disturbances. They too are human beings with a constitutional right to human dignity, privacy, and property, even if it is only a little. It is the same sentiment expressed by Justice Yaqub in 2001 in the now infamous Grootboom decision, where Yaqub reminds us The Constitution will be infinitely less than its paper if the conduct of the state concerned with housing is determined without regard to the fundamental constitutional value of human dignity. In short, I emphasize that human beings are required to be treated as human beings. This is the backdrop against which the conduct of the state towards the homeless must be seen. In 2005, in what has also become quite a famous case, is PE municipality versus various occupiers, Judge Sachs went even further and pointed out that it is not only the dignity of the poor that is assailed when homeless people are driven from pillar to post in a desperate quest for a place where they and their families can rest their heads. Our society as a whole is demeaned when state action intensifies rather than mitigates their marginalization. The integrity of the rights-based vision of the Constitution is punctured when governmental action augments rather than reduces denial of the claims of the desperately poor to a decent existence. Now, these words by Yacoub and Sachs are a reminder of the particular responsibility that South Africa has to the poor, the marginalized, the homeless, and the landless in terms of the Constitution. Any conduct that is undertaken in terms of bylaws, policies, or vague interpretations of legislation that tramples on these constitutional rights should, in my view, be approached with circumspection. The sad thing, of course, is that these are only some of the cases that actually go to court. And I shudder to think how many of these cases are actually happening on a daily basis that we don't know about, or that where these marginalized groups don't have an opportunity to go to court. I would argue that conduct in flagrant disregard of constitutional rights has no place 25 years into our constitutional democracy. And so I guess the questions that I'm keeping myself busy with at the moment, or that are preoccupying me at the moment, are to what extent is the law enabling this type of conduct? And what is the role of bylaws in society, specifically in relation to the interrelationship between bylaws, policies, and legislation, when what can be used, and when it's appropriate to use one vis-a-vis the other one? I'm also I'm also specifically concerned with, and this is more related very directly to property law. The other two are more general questions, but to the extent at which PI, the Prevention of Illegal Eviction Act, should be providing more substantive protection where it doesn't at the moment provide substantive protection. And to what extent do we need to read in interpretations that were not essentially meant or thought of when the piece of legislation was enacted in the first place? Are we maybe at a time where we need to amend PI to allow for conceptions or maybe even understandings of, for instance, a home that we didn't necessarily think of when PI was enacted firstly? So those are some of the, I think, questions which I don't have answers to at the moment. But besides my one-year-old keeping me at night, these are the other things that keep me up at night at the moment. But I'm hoping that these are, I can shape the questions in such a way that the answers potentially unlock unintended possibilities. Maybe it won't reduce poverty in terms of the first sustainable development goal, but I think it will do a very important job, and that is to prevent further marginalization of a group that for the longest time has been degraded, devalued, and dispossessed. So that's where I am at the moment in terms of my research. My group in various ways are working towards unraveling some of the issues in that regard. I want to thank all of you for your time and your attention. I really enjoyed the lecture.